Hello, everybody. My name is Rafael Lazaro, and I am the owner of Lazaro Law Group, an employment law firm based in Chicago, Illinois. Today, I am so excited because I get to talk to you about a new federal civil rights law. Yes, Congress hasn't passed a civil rights law in a long time, but this year it passed the Pregnantworkers Fairness Act. That law is a game changer, and today I'm going to give you some tips in terms of how to manage pregnant employees in the workplace based in light of the new law. Okay, so without further ado, here we go. Number one, laws that are game changers require a different mindset. Yes, absolutely. You know, as HR personnel and as employment lawyers, we were taught that pregnancy is not a disability, that pregnancy rarely requires a reasonable accommodation. Under this law, if an employee raises their hand and says, I need a reasonable accommodation, the general rule should be absolutely yes, I'm going to give it to you. Why? Why is that? The law does two main changes. Number one, whereas under the ADA, the Americans with Disabilities Act, the employee has to be qualified, and to be qualified, you have to be able to perform the essential job functions. Under this law specifically says that the pregnant person does not have to be able to perform the essential job functions. The only caveat is that only on a temporary basis. That means that for pregnancy, a lot more people are going to be covered under the law, and a lot more people, the employer is going to have to provide a reasonable accommodation to those people. The second change that the law makes is regularly or generally, the employer does not have to provide a reasonable accommodation when that accommodation results in undue hardship. Because we're dealing with pregnancy, and pregnancy is a temporary condition, that is going to be rarely the case, meaning that the employer is rarely going to be able to show that there's undue hardship, because we're only talking about a specific period of time when the employee is pregnant, or before and after. And that leads me to my second point. This law is not only about the time that the employee is pregnant, it also covers the time period before and the time period afterwards. It is about pregnancy, childbirth, and any related medical condition. That means that infertility treatment before the employee gets pregnant is going to be covered. I have an obligation to provide a reasonable accommodation in most situations when the employee is receiving infertility treatments. Afterwards, depression related to pregnancy, that's going to be covered. Okay, lactation is going to be covered. Okay, so that's tip number two. The law covers before, during, and after. Tip number three, and very importantly, the law says specifically that the employer cannot impose their own idea of what is a reasonable accommodation. You know, there is always a knee-jerk reaction when it comes to pregnancy and accommodations that I'm simply going to send the employee home. Under this law for leave, just go home until you have your child. Under this law, that should be the last resort. This law really wants to keep the employee at work. And it specifically says that it is unlawful for the employer to send the employee home without entering into that interactive process. The last thing I'm going to say about leaves is the following. Even if the employee has exhausted FMLA, even if the employee has exhausted sick leave or vacation or PTO, you still have to consider as a potential reasonable accommodation leave. Absolutely. That's an exception to the general rule. So those are my tips. The most important thing that I want you to remember is that if you're an HR professional or an employment lawyer, there needs to be a shift in mindset. And now, as a general rule, the law is going to require reasonable accommodations for pregnant employees. I really hope that was helpful. It was super fun to make this. Thank you so much, everybody. Take care. Bye.